colleagues. First of all, I want to apologize for not being here with you yesterday. Last time I was also absent because of the lecture at the Law Faculty of Miskolc. And yesterday I was absent because of some obligation in the Constitutional Court of Serbia. The first excuse, the first absence was good. The second was not so good, but anyway, I was not here yesterday, but I saw, seeing the program, I can see that the topics were very, very interesting and various, and I can say that maybe this book we are expecting in June, I suppose that goal will be achieved, which is very ambitious, but also realistic, that book will be a unique book about the concept of the rule of law, of supranational rule of law. And my small and modest contribution is dedicated to the Venice Commission and the concept of the rule of law. This will be only the excerpt from the voluminous text, which I already given to the editors, and I would like to begin with a quotation of the first several sentences. Maybe they are not so common to the scientific paper. Where is the Venice Commission? To begin with a short tourist guide. Imagine for a moment that you do not have internet and you cannot use Google Maps. You are in Venice and you are located somewhere in Piazzale Roma, the square with the largest car garages, a bus and a train station. The easiest way by foot to Scuola Grande San Giovanni Evangelista leads across the Santa Chiara Bridge, Ponte Santa Chiara, via Fondamenta del Monastero Street, which is the entrance to the Grand Channel. After about 100 meters, right after the Carlton Hotel, turn right into the street, go straight again for about 100 meters, turn right, then immediately left, and then straight. Cross a small bridge and follow the road without turning into the alleys offered to you on the right. After about 100 meters on the left, you will find your destination. Scuola Grande San Giovanni Evangelista is the seat of the European Commission for Democracy Through Law, better known as the Venice Commission. Its name, well known in the world of the international law, constitutional law, and politics, will not be of much help to you if you refer to it among the local population. Venetians, especially if your English is too good or your Italian too bad, will most likely direct you to one of the surrounding buildings, which are probably more famous tourist sites, for example, the Scuola Grande di San Rocco. There are also other paths in the magical Venetian labyrinth that lead to our school. For example, if you're located somewhere in or around Piazza San Marco, the most famous tourist location in Venice, you will have to cross the well-known Rialto Bridge. And count on a half-hour walk, and then the school is tucked away in a passage, and from the outside, at first glance, etc., etc., etc. So, why I began with this uncommon introduction? Because the position and the role of the Venice Commission is like an official secret, I can say, even a magic, for all that come from exterior. The Venice Commission is, in a way, its role is more complex than many critics of Commission are ready to accept. On the other hand, that role is in its essence advisory. A competent and wise advisor inevitably becomes a creator and a factor whose word becomes a reference. That happened to the Venice Commission. The VC was created in 1990 as an international project, which was doomed to success in the years of great legal and social political changes that came with the fall of the real socialist bloc. One of the Commission's original tasks was to find a common constitutional denominator for practically all European states that had or aspired to have a democratic political order. Thus, the VC has developed the concept of the European constitutional heritage, which rests on democracy, human rights, and the rule of law. And according to Craig, Paul Craig is a famous author, the former member of the Venice Commission and also the famous author in the area of the rule of law, the VC became one of the creators of transnational constitutional law. A specific and unique philosophy characterizes the practical work of the VC, which is based on flexibility and dialogue. Although the VC is often referred to as an independent consultative body, it has a specific legal status, a kind of substantial autonomy. I used that phrase because of some comparison with substantial autonomy of the autonomous province of Kosovo and Metohija, in or without in Serbia, as you wish. In relation to the in relation to the Council of Europe, the Commission was formed by the decision of the Committee of Ministers of the Council of Europe in 1990, which was preceded by a partial agreement, a legal instrument that allowed only those member states of the Council of Europe who wish to enter into this specific institutional arrangement. Although the Commission was primarily created out of the need to help the countries of Eastern and Central Europe, it became an almost equal need in the so-called stable Western democracies, not only for the promotion of democracy through law, but also for finding the unifying principles of the future European political community. And the future of the Commission is largely determined by finding a way out of the political and all-encompassing crisis of the European community, but also of a global crisis of the inter- and supranational rule of law. Some words about the VC rule of law checklist. I can say the attempt to measure the rule of law in practice. The 21st century has led to a gradual sobering from the misconception that the rule of law is a universal principle of universal content. It is not enough just to proclaim it in constitutions and declarations, international conventions and treaties, or to refer to the principle as is generally done in the practice of the European Court of Human Rights and other courts. The key challenge is to find first an operational and functional definition of the rule of law. The VC was in a certain sense called out by the Parliamentary Assembly of the COE in the resolution from 2007 on the principle of the rule of law. After that, the VC adopted a report on the rule of law of 2011. The rule of law as a concept is originally and primarily linked to the national state legal order, but it has an increasingly pronounced inter- and supranational character, scope, and importance. That is why it was created the rule of law checklist in 2016. Firstly, although the checklist mainly consists of legal guarantees, the rule of law depends equally, if not more, on the legal and political culture of a country. Therefore, the checklist is valid to the extent that it is used in the context of a specific country, not as a formula, but as an open system of benchmarks that a country satisfies at a specific moment. Those benchmarks are legality, legal certainty, prevention of abuse of powers, equality before the law and non-discrimination, access to justice, the examples of particular challenges to the rule of law, for example, corruption and conflict of interest, and collection of data and surveillance. Checklist is an expression of awareness that the rule of law is not indefinable in the proper sense, but that it could be possibly measurable. Simona Granata Mengini, director of the Venice Commission, says, "The rule of law is not all or nothing. Compliance with the rule of law is a priority of our times and should be pursued and enhanced on structural matters or on matters of institutional functioning." Some sentences, some words about the VC opinions between law and politics. Sorry, I just turned. Okay. Yes, it's okay. The VC issued country-specific opinions at the invitation of the bodies of the states whose acts are being analyzed, or on the initiative of the bodies of the COE and other international organizations. When the state addresses the Commission, it may do so for various reasons: to seek an expert opinion on the quality of its proposed legislation, to invoke the authority of the opinion of the Commission as one of the instruments for solving internal political dilemmas and conflicts, in order to harmonize national legislation in the most adequate possible way with international standards in some area, etc. Before the plenary session, a draft opinion is being discussed in the corresponding subcommittee. State representatives and rapporteurs can also meet the day before the plenary session in order to agree some details in the draft opinion. The opinion is adopted at the plenary session by the votes of the majority of members, provided that the majority of the members of the Commission are present. However, the rule is that opinions are adopted by consensus. And it is very interesting that there is a little or no discussions at the plenary sessions about the topics which are on the agenda of the plenary session. So about a kind of Venetian magic and Venetian democracy, the Venetian understanding of democracy. Operability and flexibility as important features of the VC work methodology created a need for a special type of opinion which is somewhat different from ordinary opinions. Those are urgent opinions, which are issued in exceptional cases, although the number of such opinions has increased over time so that they no longer represent an exception in the work of the Commission. Their common denominator is the necessity for the Commission to declare its views and recommendations regarding a text without waiting for the next plenary session. Another type of opinion, which is called follow-up, whenever there are new developments concerning an adopted opinion, the Secretariat will report the plenary session under the item follow-up to previous opinions. The statute defines only a variant of follow-up that has crystallized in the work of the Commission. It is an opinion on a legal issue in connection with which it has already given earlier opinions. The practice has also produced interim opinions when the Commission considers that its assessment of the topic requires further developments. Bearing in mind that the process is ongoing, the Commission should not take its final position on the issue. According to the words of Granata Menghini, formally speaking, the Commission is an advisory body, and the recommendations expressed in its opinions are just that, recommendations which are not legally binding upon authorities to which they are addressed. The absence of legal sanctions is the first soft spot in the methodology of the Commission's work. Another soft spot is the absence of a system or effective monitoring mechanisms for compliance, i.e. the implementation of its opinions for specific countries. The third concerns the impossibility to measure with sufficient certainty the impact of the Commission's opinions. According to the Granata and Martin Kier, which is the member of the Venice Commission substitute member, but very important person in the Venice Commission from the Netherlands, the VC, in fact, brings technical legal argumentation to the political debate, but remains to the greatest extent possible outside the political forum. However, it cannot be said, that's my opinion, that the VC has consistently managed to stay outside the political forum. Flexibility as a basic feature of this body's work methodology allowed many of its opinions to be, quotation, the result of the mutual relationship between the work of the Commission and the relevant political forces at play. This flexibility, in fact, is shown as the main advantage, but at the same time as the main limitation of the influence in addressing rule of law issues and in maintaining constitutional standards and fundamental norms, according to Clayton. According to the same author, although its opinions are generally reflected in the adopted legislation, the Commission does not impose its solutions, but adopts, and that is very important, a non-directive approach based on dialogue. The power of the Commission is therefore the power to persuade, although it seems that where the state itself requests an opinion, it is normally implemented. It is therefore very difficult to assess the Commission's effectiveness in shaping constitutional and human rights standards. That are the words of Clayton. And my words also, I can say very generally, that the opinions are not, or for the most part, are not political documents. They are drafted using legal methodology and legal argumentation. There is no doubt that the time frame is also relevant, and it often does not favor the quality of opinions. The opinions are neither abstract nor general documents. They will be applied only if the Commission standards in a certain area, judiciary, constitutional judiciary, elections, are adapted to specific national socio-political circumstances. For example, now the Constitutional Court of Serbia has some important decision to bring in the next period concerning maybe the electoral result in Serbia and Belgrade. And I can say to you, I can say a little secret, because I found some important extract in the Venice Commission opinions that can prove that the Serbian opposition is not right when it requests from the Constitutional Court to annul the whole electoral procedure. But it is said in the Venice Commission documents, you must read it, you must find that extracts, and you must interpret it in the way which is in accordance with the protection of the national rule of law concept, and of course in accordance with those Venetian standards which are developed during more than 3 decades from 1990. Sorry. The implementation of the opinion is important for the state due to its political needs, but it is certainly not much less important for the Commission itself, due to the strengthening of its expert legitimacy and continuous confirmation of the mission for which it was established. In that sense, it has to be acknowledged that the advice offered by the Commission has always been, at least to a certain degree, more than purely advisory, and that the level of observance of opinions by the Commission cannot be explained by the quality of advice offered and its independence. Very important, the observance of the opinion of the Commission is also, at least in part, the result of the interplay between the work of the Commission and the political forces, i.e. the state bodies and also non-governmental organization of the state, which are in the concrete process. In summary, it is possible to talk about 3 dimensions of the Commission's impact on the legal order of the country in question. The first is quantitative, the second is qualitative, and the third concerns follow-up in the true sense. The quantitative dimension refers to the volume of adopted recommendations, ultimately to the question if legislation has been changed at all. The qualitative dimension of impact refers to the quality of the amendments, more precisely to the extent and the way the recommendations from the opinion are implemented in the final text of the Constitution or the law. The Commission can at least have information and present it as a classic follow-up at the next plenary session. That follow-up is a summary report about which recommendations from the opinion can be followed, i.e. have become an integral part of the applicable law of the concerned state. The third dimension of impact refers to the question of whether the adopted legal amendments are implemented or applied. That impact of the Commission almost never exists, because the Commission is not even in charge of dealing with it. According to Granata, Menghini and Kier, the assessment of the follow-up given to an opinion should, however, remain outside the realm of the Commission. The Commission's assessments are meant to contribute to the domestic discussions, not to replace them. Ownership of the constitutional and institutional design of a country is a fundamental feature of its accountability towards its citizens. States should not be given the pretext of blaming an external advisory body for possible mistakes or lack of success. In conclusion, it can be concluded that the basic idea of constitutional law as a prohibition for the excessive influence of any, even international legal or political factor in the constitutional redesign of a nation state was and remains one of the guidelines in the work of the Commission. And what about the future? What about the challenges of the rule of law? Just a few words. The central question is whether the Commission will and can maintain its professional relevance, referentiality and operability in a world that will one day be born again, when cataclysmic attacks on the traditional concept of international legal order and the rule of law go to an end. We should not forget that the VC was created as an institutional realization of a humanistic, at that time very useful and above all feasible idea of national legal orders that rest on common supranational principles of the rule of law. At this point, just one thought. We would like to mention only that the Commission should pay special attention to that in the coming period. It is a re-examination of one of its traditional views on the division into old and new democracies. That division, apparently justified in 90s, is today, 90s of the 20th century, is today, objectively speaking, quite far from the reality of most member states of the COE. In general, many once new democracies have become stable. They are established and function on generally accepted European standards. Many so-called old democracies are not stable as they once were, or as it was presented before. The rule of law is facing new challenges everywhere. Those challenges does not recognize the difference between old and new democracies. So that differentiation would not be a fertile ground for the further development of the Commission in the complex political, national and international context in which Venice Commission member states nowadays function. Thank you.